So I'm looking at this. So did the trial court instruct the jury in self-defense?
They did.
And the appellate court found that was harmless error?
They found it was harmless error after this discussion about whether or not to break up the jury instruction and had to do it. In that case, he did. I don't recall whether he gave the self-defense instruction or the duty to retreat. He gave that, and then they said, but it is harmless error because no reasonable jury would have accepted that. And then they mark a conclusion, Judge. The evidence showed that any belief from the defendant's part that he was in imminent danger was not reasonable. That's what I want to point out to the court. In this one, luckily, it was harmless error. Luckily, the jury did not find the wrong thing, was not dissuaded by this. But the court is saying that instruction under these is irrelevant. That's how I would present that to Your Honor.
That's my reading of it as well. So it looks like the trial court did instruct self-defense, did include, I think, remove the duty to retreat.
Yes, sir.
And the appellate court, the Supreme Court, said that the jury should not have gotten the self-defense instruction.
Yes, sir.
Mr. Smith, will let you look at that case.
I did, and Judge, and again, and just like Vincent,
Very
the court goes
fast.
on to say, very fact specific, it's talking and the circumstances of that case. So, I mean, we could pull a litany of cases where courts said that the defense was fairly raised, and we could pull the opposite and show courts that said that it wasn't fairly raised, but that's not the law. We're not just pulling cases and say, well, it's okay, they didn't find it, so you can't find it in this case. The standard is very low. It's below a preponderance of the evidence. And all the facts have to be taken in the light most favorable to the defendant. I read out all of them. For the state to say that you didn't hear any of that, basically I just used the testimony that was reported on the live stream. I went through his entire testimony and gleaned and pulled out all of those facts. I'm not faulting the state. I mean, we're all busy, we're all doing things, and our minds on different things, and we can't always pay attention like you hope. But Judge, this case is different than Vincent. This case is different than Perrier. And we need to give the defendant, we need to hold all of these facts and circumstances in a light most favorable to him. And if we don't, we're just creating an issue for the case to possibly come out.
May I ask you a question?
Yes, Judge.
So I understand your argument that the case is basically saying that self-defense should not have been instructed, or was improperly instructed. And they're fact specific as you were. So what was the deadly aspect that Mr. Wright presented to your client when it seems that he said, I don't know if he's a UFC fighter. I don't know if he has a gun. It's almost like he's admitting he has no belief. It's a question mark, perhaps, but he has no reasonable belief that his life is in danger.
Well, I think that is a rhetorical question, Judge. It's showing that he did, in fact, believe his life was threatened because he couldn't know what that person was going to do. He was in a bad area. He wouldn't leave him alone. He squared up against him. That's a rhetorical question that shows, in fact, in his mind, he did believe that he was in danger. We need to take that fact in the light most favorable to Mr. Roberts. The fact that in and of itself is a fact that shows that self-defense is fairly raised. The state tried to impeach him on that. I mean, they know that it's fairly raised.
No, we don't.
Well, I'm still looking for the fact that fairly raises it. He says, I was afraid. So when we ask why he was afraid, what fact is present in the record that gives some type of anchor to a reasonable belief of fear, I don't think it ever got that far, but I want to give you a chance to respond to that.
I think how many times in our lives does someone that we don't know in the middle of the night come up to us, confront us, use a racial slur, call us a piece of shit, square up, tell us to say it to our face, boy. So we got this idea that I think the state does, and maybe where the court's going, is that Mr. Roberts had some kind of duty to take a whipping before he used self-defense. And that's just not the state of the law. And I know maybe the facts aren't the best cases for self-defense, but it doesn't have to rise to the level of the best case for self-defense. It just has to be fairly raised, very low standard.
I mean, the closest it comes to me, it seems that his physical condition perhaps made him feel more threatened, at least more vulnerable or fragile in a situation like that. But again, when he took the stand to explain that, while he might have been fragile, the victim seems to be disengaging. The very last words that apparently he said, according to your client, is, "Becky won't say that to my face, boy," quote unquote. So it's almost like there's no imminent harm. It seemed more like your client, instead of feeling afraid, said, "Challenge accepted." And he got up to say it to his face or do something to his face, walk towards him. And that seems the opposite of feeling afraid. I'm going to give you a chance to respond to that.
Yeah, I think you're doing the same thing that Mr. Moyle did. You walk towards the man you couldn't run away from, right? Each step bringing closer and closer to the person that you claimed you were scared of. So whether or not it is reasonably raised doesn't mean that the jury will find it. It's just that we need to give them the opportunity. Every single juror needs to have the opportunity to look at the totality of the circumstances in this case, to determine if in their experiences in life, whether it be an MMA fighter on the jury, I don't know if there's one, but if I'm 20 feet away from John Bones Jones and he's saying, I'm about to get you.
Did he say that?
Well, he said, "Come say that to my face," and our client testified that he knew the situation to be that he was about to get a whooping. That's what he said. And so it's a minimal standard. Then the totality of the circumstances. The fact that he knew that his friend had been attacked close in time. It's reasonable to believe that he feared imminent serious bodily injury. In his fragile condition, he's 30 years younger, 20 years younger, 30 pounds lighter. He's an older black man with gray hair that couldn't stand a fight. And whether he didn't know that Mr. Wright had scars all over his legs and all over his arms from prior physical instances. That's what the Dr. Cogswell testified to. There's so many that he found finding that his legs and arms were scarred up. So we do have a mismatch, Judge. We've got a mismatch of ability.
Seems like the overpowered party in this, so to speak, taking the gun out of it physically, was moving away and only paused to invite your client to say it to his face, basically.
In the totality of circumstances, Judge, that was just one more confrontation. He wouldn't leave. He did start to walk away, but then he stopped walking away and re-engaged. He re-engaged multiple times on the video. You heard the testimony that they wanted him to leave. He wouldn't leave. And finally, Mr. Roberts snapped.
I think the testimony was from the witness as well, Mr. Houston. Did he leave? The answer was eventually. So there might have been some scary moments for your client, maybe Mr. Houston, while Mr. Wright was there in their proximity, boxing your guy in. Would you use your language, use his language, I guess. That went away, it seems, from disengaged, was walking.
A few seconds, Judge, is all we're talking about heat of the moment. We give police officers the benefit of the doubt when they make a wrong decision. In this particular case, deadly force was used because our client feared serious bodily injury. And so totality of circumstances show that while that may have been, he may have misperceived the threat, he in fact still had one.
Wish to argue anything you haven't argued yet?
No, Judge.
State one, All
No, Judge.
right, Mr. Smith makes a good point when he says these are very fact specific. And even though there are case law that's been reviewed favors not instructing self-defense on the facts in Harrier and even in Benson as well. Looking at the facts in this particular case, the court does understand that it needs to be fairly raised. There has been testimony that certainly Mr. Roberts' age, his physical condition put him at a disadvantage in some way. However, the video shows that Mr. Wright was disengaging, in the process of slowly disengaging, perhaps, but moving away from a confrontational stance. He was out of their space, and according to, again, Mr. Roberts' testimony, he's the person who chose to testify and let us know what was going on inside his head. And the most he got was a question mark. He didn't know if the victim was armed. He didn't know if the victim was a UFC fighter, to use his term. And so I don't think a question mark fairly raises it. I think they're, as Mr. Smith said, very fact specific. I don't see a fact other than the condition of his client as a fact. However, there seems to be zero evidence that the victim was armed or capable of inflicting or threatening deadly force upon the defendant. I really want to give the defense full range to be able to raise any facts if it could throughout this to see if it was fairly raised. Right? It doesn't have to establish self-defense, it just has to fairly raise it. I think it's been fairly raised in this particular case. Based on the facts the defense has said, the defense's argument, as offensive as they may be, as far as what the court has to look at, whether they were indicative of a deadly threat justifying self-defense instruction, or at least raising the possibility of self-defense. I don't think it meets that very low standard. The defense request to instruct self-defense's request to instruct self-defense be overruled. Brings us to another question. I don't know if the parties got a chance to read more recent Tennessee Supreme Court case, Curry. If we get to a sentencing hearing, maybe argue this later, unless you want to argue it now. Curry basically examined in great detail down to the granular level of what a crime of violence happens to be, and concluded that a robbery might be a crime of violence, but isn't necessarily a crime of violence, which, according to Curry, seems to indicate that the state would have to put on proof where a jury could find that the robbery was an actual crime of violence. We can talk about that now if you wish, or we can get into the jury instructions for the guilt innocence phase and let you look at it later. How are you going to do it?
That makes the most sense to me, Judge. That's argued things
Okay.
that most pressing.
State feel the same way.
Yes, Judge.
Any other suggestions, additions, modifications, deletions to the jury instructions?
Is the court going to leave in the standalone prior statement of defendant?
No. I think it's either prior statement or admission against interest or confession. In this particular case, I think it qualifies. Be more specific than prior statement, but less confession level, which would be statement against interest.
Gotcha. I just wasn't clear if that was removed.
Any other requests? If not, I think I've got them tweaked. I'll save them, email them to the parties, let them look at them, when both of you are finished, we can bring the jury in and proceed with the trial.
Judge, will we do instructions before argument?
Yes, we'll do most of it before argument. Way it'll work out is bring the jury in, make sure that they haven't been exposed to any media. I'll ask the defense if they want to call on their witnesses. I'm presuming the defense is going to rest. At that point, I'll let them know that they've heard all the evidence. I'll do most of the charge. Then closings will occur, and there's a couple paragraphs I'll read before we send them back.
Yes, sir. Thank you, Judge.
The defense if they want. We got past it already. There's your copy.
So just so I'm clear, we're going to get an email with the tweet jury instructions. The court's made its ruling on self-defense not being fairly raised. It's 11 o'clock already. I would ask to bring the jury in, close the proof, break them for an early lunch, so we have time to look at those jury instructions and prepare our closing argument. The changes that you can make. Come back right after lunch and start.
Well, was that
It'll be here at 12:30.
12:30?
Yes, sir.
What we'll do is this, do the same one that I emailed on Friday. So give you 15 minutes to look at it. I don't think it's going to be much of a change than what you had other than what we talked about today. So I'll just go in front of them.
Judge, the state's position is we would like to just go into closing arguments.
Well,
That's our position.
We got lunch coming between 12 and 12:30. Had to order it yesterday. So there's nothing for them to do until then. So most of the instructions or the significant aspects we've argued about. And, I'll give you a chance to look over the file in just a second. And Nancy, could you grab the jury instruction from the printer, please? There should be 2 copies, one for the state, one for the defense. Judge, can you approach the chair? They need some extra time, part time to adjust for closings. So if we can get the jury's lunch here a little earlier, I'm inclined to go ahead and take that break and let you look at that.
Thank you.
Roberts. Judges, the court aware your computer's up there.
Yes,
Okay.
I'm going to read the jury instructions, let the jury follow along.
Yes, sir.
I included the minor instructions on identity because it seemed like it was contested, the least comprehensive.
Yes, sir.
See if Nancy's got those jury instructions yet?
Yes, Judge.
Judge, I'm gonna run to the back. I'll be right back.
She said she was texting me.
Two hard copies. Rather than email, we just print off hard copies.
Thank you.
You just have like additional time to review the hard copy. If either side wants more time to review the hard copy, basically it incorporates the tweaks we did today. Other than that, they're the same as what got emailed last Friday. The parties like more time to look at them before we bring the jury into charge.
Yeah, just briefly on that section.
Okay. Self-defense was taken out, and prior
Did you
inconsistency.
say you tweaked identity?
There were a number of different charges for identity that are possible. Since this one identity is really not contested, I just used the smaller instruction, the less comprehensive one for identity. I think the defense is contesting identity in this case. It's a matter of state of mind. More comprehensive instruction. It's time to talk about it, Mr. Smith.
Yeah, I think the one thing I would consider is the second paragraph of the identity section. The court further charges that from the whole proof of the case are satisfied beyond reasonable doubt the defendant committed the charge or included offense. So that includes all the elements, right? That's all it is, not just identity.
Hang on a second.
Um,
I'm at the identity charge. What are you looking at?
The second paragraph. Court further charges you that if from the whole proof of the case you're satisfied beyond a reasonable doubt that the defendant committed the charge or included offense, and you're satisfied beyond a reasonable doubt that he's been identified. So it's two things. It's guilty of the whole thing.
It's a both and.
And you've identified. It's your duty to convict him. Now, the second part, on the other hand, if you're not satisfied with the identity from the proof, or you have reasonable doubt as to whether he has been identified on the whole body of the proof, then you should return a verdict not guilty. That leaves out the part that was in the first part about, they got to find beyond reasonable doubt he's guilty of the crime charged, not just being guilty of identity. So I think there's going to be similar language.
I think that last paragraph does cover it in the sense that the paragraph, there's in the sentence at the beginning where it's a both and, he's been identified and he committed a charge offense. It's the jury's duty to convict him. That second sentence just basically means that if identity hasn't been proven, you don't even get to the second part. It's a not guilty because he hasn't been properly identified. So I don't think that prejudices.
I can see how you read that. All right, just we reviewed the final jury instructions as they pertain to the guilt phase of count one.
Okay. State, ready to go still?
Yes, Judge. We're good to go.
Okay, we'll bring them in. I'm gonna go over the admonition, ask the defense if they're gonna present more proof. Then we'll charge them and send them to lunch. All right, ladies and gentlemen, out in the gallery, this is gonna take about 45 minutes. If you want to stand and stretch, now's a good time to do it, because we'll be sitting down for about 45 minutes. All right, we'll bring in the jury, please. Please be seated. Welcome back, jurors. I hope you had a restful, long weekend. We'll start as always, but just making sure that everyone's able to prevent themselves from being exposed to any media, from forming any opinion about the case, or anything else from the court's admonition. Is everyone able to abide by the court's admonition? Nod your head, please. Thank you. All right, counsel approach. Mr. Smith, will defense be calling any more witnesses?
No, Your Honor.
State offering any rebuttal proof?
No, Judge.
Ladies and gentlemen, you've heard all the proof you're going to hear in this case. The reason I'm getting these questions asked that you asked about the last few deal with witnesses on the stand. Parties have decided not to call any more witnesses, so you've heard all the proof you're going to hear in this case. What will happen next is I'm going to read you some very long jury instructions. It'll take about 30 or 45 minutes at least. You will get a copy of these to take back with you to the jury room, so you don't have to write these down. Please pay attention. It will cover some aspects of the trial that are very important. And you'll see when you read them, just make a note that to go back and read them, you get your full jury instructions. Then, based on time, you'll go to lunch. After the jury instructions, you'll come back. Parties will deliver their closing arguments. At that point, you'll be sent to deliberate. Members of the jury, the evidence in this case has been completed. You will now be instructed as to law applicable in the case. This covers your duties and general rules that apply in every case. It also covers the offenses that are charged and included in the presentment and lists their elements. It includes some rules that you must use in evaluating particular testimony and evidence. Finally, also includes rules that you must follow during the deliberations in the jury room and the possible verdicts that you may return. It is your duty to carefully consider all of these instructions. The order in which these instructions are given is no indication of their relative importance. Moreover, do not assume that because a particular instruction is given, it suggests anything about the facts of this case. You should not single out any one form of instructions as exclusion of one or others, but you should consider each instruction in light of and in harmony with others. Count 1, presentment 316-495, charged the defendant, Darryl Roberts, the offense of first-degree premeditated murder on or about September 28, 2023, in Hamilton County, Tennessee. This charge includes the following offenses: first-degree premeditated murder, second-degree murder, voluntary manslaughter, aggravated assault, reckless homicide, reckless aggravated assault, criminally negligent homicide, assault, and reckless endangerment. The presentment in this case is the formal written accusation charging the defendant with one or more crimes. It is not evidence and does not create any inference of guilt. To presentment 316495, the defendant, Darryl Roberts, pleads not guilty. The plea operates in law as a denial of every allegation of guilt contained in the presentment, every element of fact, and the offenses charged in the presentment. The law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial. It is not overcome unless from all the evidence in the case you determine beyond reasonable doubt the defendant is guilty of an offense charged or included in the presentment. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. Reasonable doubt is that doubt created by an investigation of all the proof in the case, and an inability after such investigation to let the mind rest easily as to certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and the certainty is required as to every element of proof necessary to constitute the offense. The state has the burden of proving beyond reasonable doubt all the elements of the offense, and that the offense was committed before the presentment was found and returned on December 6th, 2023. The burden of proving by preponderance of the evidence that an offense charged or included in the presentment was committed in Hamilton County, Tennessee. Proof by preponderance of the evidence means that the greater weight of the evidence must be in support of the state's contention. The venue of an offense lies in the county where the offense will consummate. If you find that the state has failed to prove by preponderance of the evidence that an offense charged or included in the presentment was commenced or consummated in Hamilton County, Tennessee, you must return a verdict of not guilty. At times during the trial, I ruled upon the admissibility of evidence. Do not concern yourself with these rulings, neither by such rulings, these instructions, nor any other remarks that I have made. I need to indicate any opinion as to facts or what your verdict should be. Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. Any statements will made that you believe are not supported by evidence, you should disregard them. You are the exclusive judges of the facts in this case. You are also the exclusive judges of the law under the direction of the court. You should apply the law to facts in deciding this case. You should consider all the evidence in light of your own observations and experience in life. Any person who commits the offense of first-degree premeditated murder is guilty of a crime. You define the defendant guilty of this offense. The state must prove beyond a reasonable doubt the existence of the following essential elements: 1, that the defendant unlawfully killed the alleged victim, and 2, that the defendant acted intentionally, and 3, the killing was premeditated. In the context of this offense, the person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exist in the mind of the accused or even definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, It is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed through the heat of passion. The accused commits the act after the passion has subsided. Any person who commits a second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant unlawfully killed the alleged victim, and two, the defendant acted knowingly. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation of the alleged victim sufficient to lead a reasonable person to act in an irrational manner. In the context of this offense, a person acts knowingly when a person acts with an awareness that his or her conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowledge is also established if it is shown that the defendant acted intentionally. In the context of this offense, a person acts intentionally when the person acts with a conscious objective or desire to cause the death of the alleged victim. Any person who commits voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant unlawfully killed the alleged victim, and two, that the defendant acted intentionally or knowingly, and three, the killing resulted from a state of passion produced by adequate provocation of the alleged victim, sufficient to lead a reasonable person to act in an irrational manner. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation of the alleged victim, sufficient to lead a reasonable person to act in an irrational manner. Passion means any of the human emotions known as anger, rage, sudden resentment, terror, or similar emotions which renders the mind incapable of cool reflection. In the context of this offense, a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. In the context of this offense, a person acts knowingly when the person acts with an awareness that his or her conduct is reasonably certain to cause the death of the alleged victim. Any person who commits the offense of aggravated assault is guilty of a crime. To find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant intentionally or knowingly caused bodily injury to another, and two, the act resulted in the death of another. Bodily injury includes a cut, abrasion, bruise, burn, disfigurement, and physical pain or temporary illness or impairment of the function of the bodily member, organ, or mental faculty. In the context of this offense, a person acts intentionally with respect to the nature or result of his or her conduct, and it is the person's conscious objective or desire to engage in the conduct or cause the result. In the context of this offense, a person acts knowingly with respect to the nature of the circumstances surrounding or result of his or her conduct, and the person is aware of the nature of the conduct, the circumstances that exist, or the conduct is reasonably certain to cause the result. Any person who commits the offense of reckless homicide is guilty of a crime. You find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant killed the alleged victim, and two, the defendant acted recklessly. In the context of this offense, a person acts recklessly when the person is aware of but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessness is also established if it is shown that the defendant acted intentionally or knowingly. In the context of this offense, the person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. In the context of this offense, the person acts knowingly, and the person is aware that his or her conduct is reasonably certain to cause the death of the alleged victim. Any person who commits the offense of reckless aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant recklessly caused bodily injury to another, and two, the act resulted in the death of another. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness, or impairment of the function of a bodily member, or or mental faculty. In the context of this offense, a person acts recklessly with respect to the circumstances surrounding or a result of his or her conduct the person is aware of, that consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessness is also established if it is shown that the defendant acted intentionally or knowingly. In the context of this offense, a person acts intentionally with respect to the nature or result of his or her conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. In the context of this offense, a person acts knowingly with respect to the nature of the circumstances surrounding or a result of his or her conduct. The person is aware of the nature of the conduct, that the circumstances exist, and that the conduct is reasonably certain to cause the result. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, the defendant's conduct resulted in the death of the alleged victim, and two, the defendant acted with criminal negligence. A person acts with criminal negligence, and the person ought to be aware of a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of criminal negligence is also established if it is shown that the defendant acted intentionally, knowingly, or recklessly. In the context of this offense, a person acts intentionally when it is the person's conscious objective or desire to cause the death of the victim. In the context of this offense, the person acts knowingly when the person is aware that his or her conduct is reasonably certain to cause the death of the alleged victim. In the context of this offense, the person acts recklessly when the person is aware of but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. If you find beyond a reasonable doubt that the defendant was criminally negligent, you must also find that the death of the alleged victim was the approximate result of the defendant's criminal negligence. The defendant's actions need not be the sole or immediate cause of death. If you find that the direct cause of death was an act of the victim or third party, before you can convict the defendant, you must also find beyond a reasonable doubt the act of the victim or the third party causing the death was a natural and probable result of the defendant's negligence. Any person who commits the offense of assault is guilty of a crime. If you find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of essential element. That the defendant intentionally, knowingly, or recklessly caused bodily injury to another. Bodily injury includes a cut, abrasion, bruise, burn, disfigurement, physical pain, or temporary illness, or impairment of the function of a bodily member, organ, or mental faculty. In the context of this offense, a person acts intentionally with respect to the nature or result of his or her conduct, and it is the person's conscious objective or desire to engage in the conduct or cause the result. In the context of this offense, a person acts knowingly with respect to the nature of the circumstances surrounding or a result of his or her conduct, and the person is aware of the nature of the conduct, that the circumstances exist, that the conduct is reasonably certain to cause the result. In the context of this offense, a person acts recklessly with respect to the circumstances surrounding or a result of his or her conduct, and the person is aware of, but consciously disregards, a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances, as viewed from the accused person's standpoint. Any person who commits the offense of reckless endangerment is guilty of a crime. We define the defendant guilty of this offense. The state must prove beyond a reasonable doubt the existence of the following essential elements. One, that the defendant engaged in conduct which placed or might have placed another person in imminent danger of death or serious bodily injury. And two, that the defendant acted recklessly. Serious bodily injury means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss, or substantial impairment of the function of a bodily member, organ, or mental faculty. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness of the function of a bodily member, organ, or mental faculty. For the threat of death or serious bodily injury to be imminent, the person must be placed in a reasonable probability of danger as opposed to a mere possibility of danger. Before you convict the defendant, the state must show beyond a reasonable doubt that a person or class of persons was in the zone of danger. The zone of danger is that area in which a reasonable probability exists that the defendant's conduct would place others in the imminent danger of death or serious bodily injury. In the context of this offense, a person acts recklessly with respect to the circumstances surrounding or a result of his or her conduct. The person is aware of, consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from standard of care that an ordinary person would exercise through all the circumstances as viewed from the accused person's standpoint. The requirement of recklessness is also established if it is shown that the defendant acted intentionally or knowingly. In the context of this offense, a person acts intentionally with respect to the nature or result of his or her conduct, and it is the person's conscious objective or desire to engage in the conduct or cause the result. In the context of this offense, a person acts knowingly with respect to the nature of circumstances surrounding or result of his or her conduct, and the person is aware of the nature of the conduct, that the circumstances exist, or that the conduct is reasonably certain to cause the result. The court charges you that the identity of the defendant must be proven in the case as part of the state to your satisfaction beyond a reasonable doubt. In other words, the burden of proof is on the state to show that the defendant now on trial before you is the identical person who committed the charge or an included offense. In considering the identity of a person, the jury may take into consideration all the facts and circumstances in the case. The court further charges you that if, from the whole proof of the case, you are satisfied beyond a reasonable doubt that the defendant committed the charge or an included offense, and you are satisfied beyond a reasonable doubt that he has been identified as the person who committed the charge or included offense, then it would be your duty to convict him. On the other hand, if you are not satisfied with identity from the proof, or you have a reasonable doubt as to whether he has been identified from the whole body of the proof in the case, then you should return a verdict of not guilty. The state must prove beyond a reasonable doubt the culpable mental state of the accused. Culpable mental state means the state of mind of the accused at the time of the offense. To determine the state of mind of the accused at the time of the commission of the offense, you must consider all the evidence. For each offense, the state of mind that the state must prove beyond a reasonable doubt is contained in the elements of the offense set forth in the instruction on the offense. The defendant can be convicted of any degree of homicide. The state must have proven beyond reasonable doubt that the death of the deceased was proximately caused by the criminal conduct of the defendant. The proximate cause of death is that cause which, in natural and continued sequence, unbroken by any independent intervening cause, produces the death, and without which the death would not have occurred. The defendant's conduct need not be the sole or immediate cause of death. The acts or omissions of two or more persons may work concurrently to proximately cause the death. In such a case, each of the participating acts or omissions is regarded as a proximate cause. It is not an offense that the negligent conduct of the deceased may have also been a proximate cause of the death. However, it is a defense to homicide. The proof shows the death was caused by an independent intervening act or omission of the deceased, or another which the defendant, in the exercise of ordinary care, could not have reasonably have anticipated as likely to happen. However, if in the exercise of ordinary care, the defendant should have reasonably anticipated the intervening cause, that cause does not supersede the defendant's original conduct. The defendant's conduct is considered the proximate cause of death. It's not necessary that the sequence of events for the particular injury be foreseeable. It's only necessary that the death fall within the general field of danger, which the defendant should have reasonably anticipated. If you find that the defendant's acts, if any, did not unlawfully cause or contribute to the death of the deceased, or if you have a reasonable doubt as to this proposition, you must find him not guilty. Guilt of the defendant, as well as any fact required to prove, can be established by direct evidence, by circumstantial evidence, or by both combined. Direct evidence is defined as evidence which proves the existence of the fact of issue without inference or presumption. Direct evidence may consist of testimony of a person who has perceived by the means of his or her senses the existence of a fact sought to be proved or disproved. Circumstantial evidence consists of proof of collateral facts and circumstances which do not directly prove the fact of issue, from which that fact may be logically inferred. It is your duty to decide how much weight to give the direct and circumstantial evidence. The law makes no distinction between the weight that you should give to either one, or say that one is any better evidence than the other. You should consider all the evidence, both direct and circumstantial, and give it whatever weight that you believe it deserves. It is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. 1, was the witness able to see or hear clearly? How long was the witness watching or listening? Was there anything else going on that might have distracted the witness? 2, did the witness seem to have a good memory? 3, how did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions? 4, has there been any evidence presented regarding witnesses' intelligence, respectability, or reputation for truthfulness? 5, does the witness have any bias, prejudice, or personal interest in how the case is decided? 6, have there been any promises, threats, suggestions, or other influences that affected how the witness testified? 7, in general, Does the witness have any special reason to tell the truth, or any special reason to lie? 8, all in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or is simply mistaken. People see and hear things differently. Witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It's also a good idea to think about which testimony agrees best with the other evidence in the case. You may conclude, however, that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things, but told the truth about others, you may simply accept the part that you think is true and ignore the rest. The defendant, having testified on his own behalf, his credibility is determined by the same rules by which the credibility of other witnesses is determined. You will give his testimony such weight as you think it is entitled. The testimony of a witness may be discredited or impeached by careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statements of witnesses do not affect their credibility, unless it should plainly appear that some witness has willfully testified falsely. The testimony of a witness may also be impeached by proving that he or she has made a prior inconsistent statement, that is, a material statement that he or she made out of court that is at variance with his or her testimony on the witness stand. However, the earlier statement has brought your attention for the sole purpose of discrediting or casting down on the accuracy of the witness's present testimony here at trial. You may not use the witness's earlier statement as proof that something said in it is true. In addition, testimony of a witness may be impeached by showing that the witness previously has been convicted of a felony. It is a crime punishable by imprisonment for a term of years, or not dishonesty or false statement. Prior conviction does not mean a witness is not qualified to testify, but you may consider this circumstance as one factor in determining the witness's credibility. You may decide how much weight to give any prior felony conviction and crime of dishonesty that was used to impeach the testimony of that witness. That said, if from the evidence presented, you find that the defendant has been convicted of a prior crime, you can consider the conviction only to help you decide whether to believe his testimony and how much weight to give to it. You may not consider the prior conviction as evidence that the defendant is guilty of the crime for which he is now on trial. When the testimony of a witness is impeached, the jury has the right to disregard his or her evidence and treat it as untrue, except where it is corroborated by other credible testimony about the facts and circumstances proved on the trial. Evidence has been introduced in this trial of a statement or statements about the defendant made outside of the trial to show an admission against interest. An admission against interest is a statement by the defendant that acknowledges the existence or truth of some fact necessary to be proven to establish the guilt of the defendant, or which tends to show the guilt of the defendant, or is evidence of some material fact but not amounting to a confession. While this evidence has been received, it remains your duty to decide if in fact such statement was ever made. If you believe the statement was not made by the defendant, you should not consider it. If you decide the statement was made by the defendant, you must judge the truth of the facts stated. And so determine, consider the circumstances under which the statement was made. Also consider whether any other evidence before you tends to contradict the statement in whole or in part. You must not, however, arbitrarily disregard any part of any statement. Rather, should consider all of any statement you believe is made and is true. You are the sole judge of what weight should be given such statement. If you decide a statement was made, you should consider all the evidence, all the other evidence in the case to determine the defendant's guilt or innocence. trial, you heard expert testimony. Rules of evidence provide that a scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or determining the fact of the issue. A witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state his or her opinions concerning such matters and give reasons for his or her testimony. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept this opinion. Same as with any other witness, it's up to you to decide whether you believe this testimony and choose to rely on it. Part of that decision will depend on your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reasons, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with other evidence in the case. A flight of a person accused of a crime is a circumstance which, when considered with all the facts of the case, may justify an inference of guilt. Flight is the voluntary withdrawal of oneself for the purpose of evading arrest or prosecution of the crime charged. Whether the evidence presented proves beyond a reasonable doubt that the defendant fled is a question for your determination. The law makes no precise distinction as to the manner or method of flight. It may be open, or it may be a hurried and concealed departure, or it may be a concealment within jurisdiction. However, it takes both a leaving of the scene of the difficulty and the subsequent hiding out, evasion, or concealment in the community, or a leaving of the community for parts unknown to constitute flight. If flight is proved, the fact of flight alone does not allow you to find the defendant is guilty of the crime alleged. However, since flight by a defendant may be caused by a consciousness of guilt, you may consider the likely fact of flight if flight is so proven, together with all the other evidence when you decide the guilt or innocence of the defendant. On the other hand, an entirely innocent person may take flight, and such flight may be explained by proof offered or by the facts and circumstances of the case. Whether there was flight by the defendant, the reasons for it, and the way to be given to it are questions for you to determine. The court has charged the jury concerning an inference that the jury may make in regard to certain evidence in this case. However, the jury is not required to make this inference. It is the exclusive province of the jury to determine whether the facts and circumstances shown by all the evidence in the case warrant an inference which the law permits the jury to draw. The inference may be rebutted by direct or circumstantial evidence, or both, whether it exists in evidence of the state or is offered by the defendant. Although the defendant is not required by law to do so, when the defendant offers an explanation to rebut the inference raised, you should consider such explanation along with all the evidence to determine not only the correctness of the inference, also the reasonableness of the defendant's explanation. You're not bound to accept either the inference or the defendant's explanation. The state must prove beyond a reasonable doubt every element of the offense before the defendant can be found guilty. Any attempt by a person to conceal evidence is a circumstance which, when considered with all the facts of the case, may justify inference of guilt. Whether the evidence presented proves beyond a reasonable doubt that the defendant concealed evidence is a question for your determination. If this fact is proven, it alone does not allow you to find that the defendant is guilty of the crime alleged. A person entirely innocent of a particular crime may attempt to conceal evidence, and concealment may be explained by proof offered or by the facts and circumstances of the case. However, because an attempt by the defendant to conceal evidence may be caused by a consciousness of guilt, you may consider this fact, if it is so proven, together with all the other evidence when you decide the guilt or innocence of the defendant. It is for you to determine whether there was any attempt to conceal evidence by the defendant, the reasons for it, and the way to be given to it. During your deliberation, you must not communicate with or provide any information to anyone about this case by any means outside the jury deliberation room. You may not use any electronic device or media, such as a telephone, cell phone, smartphone, iPhone, or computer, the internet, any internet service, any text or instant messaging service, any internet chat room, blog, or website, including but not limited to Facebook, LinkedIn, YouTube, Snapchat, Instagram, Google, Twitter, or any other social media to communicate to anyone any information about this case or to conduct any research about this case until you have returned your verdict and the trial has concluded. During this trial, you have been permitted to take notes for your own use during the deliberations. The notes you may have taken should not be considered a transcript of the testimony. As such, once you retire to the jury room, you may refer to your notes, but only to refresh your own memory. You may not read from your notes to your fellow jurors or otherwise inform them of what you have written. The notes may contain errors, may be understood or taken out of context, since they could only pertain to part of the testimony and are not an exact account of what was said by a witness. You are free to discuss the testimony of the witnesses with your fellow jurors. Each juror must rely on his or her own memory as to what a witness did or did not say. Upon conclusion of your deliberations, the court will collect and destroy all of the notes taken by any juror. Count one of the presentment includes, in addition to the charged offense, one or more lesser offenses. The offenses are listed in order from greatest to least. In reaching your verdict on count one of the presentment, you should consider the offense. You should first consider the offense charged in the count. If you unanimously find the defendant guilty of the charged offense beyond reasonable doubt, you shall return a verdict of guilty for the charged offense. If you unanimously find the defendant not guilty of the charged offense or have a reasonable doubt of the defendant's guilt of the charged offense, you shall then proceed to consider whether or not the defendant is guilty of the next listed offense. You shall not proceed to consider any lesser included offense until you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or if you unanimously have a reasonable doubt of the defendant's guilt of the immediately preceding greater offense. If you have a reasonable doubt of the guilt of the defendant as to all the offenses charged, including count one, you shall return a verdict of not guilty of the count. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement, if you can do so while respecting individual judgment. Each of you must decide this case for yourself. Do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because the opinion of your fellow jurors or for the mere purpose of returning a verdict. When you retire to the jury room, you will first select one of your members as foreperson who will preside over your deliberations and ensure they are conducted in a businesslike way and everyone has a fair chance to be heard. When you have reached a verdict, you will return with it to this courtroom, and your foreperson will deliver the verdict forms to the court. If you find that the state has proven the defendant guilty on reasonable doubt, then you should find him guilty. If, however, you find that the state has not proven the defendant's guilt on reasonable doubt, or if you have a reasonable doubt as to the defendant's guilt, then you must find him not guilty. You will be provided with a form for all possible verdicts in this case. The jury will complete the form and your foreperson will sign and date it. The verdict form that you will receive reads as follows. With respect to count one, presentment 316, line 5, we, the jury, find the defendant Darryl Roberts, please mark one of the following verdicts: guilty of first-degree premeditated murder, or guilty of second-degree murder, or guilty of voluntary manslaughter, or guilty of aggravated assault, or guilty of reckless homicide, or guilty of reckless aggravated assault, or guilty of criminally negligent homicide, or guilty of assault, or guilty of reckless abandonment, or not guilty. Members of the jury, you have seen and heard all the evidence in this case. After lunch, parties will have the opportunity to present their closing arguments. Under the rules of criminal procedure, the state will argue first, then the defendant will have an opportunity to present his closing argument. The state may then choose to argue in response or in rebuttal to the defendant's argument. Closing arguments are designed to present to you the parties' theories about what the evidence has shown and what conclusions may be drawn from the evidence. Remember, what is said in closing arguments is not evidence. You have already heard and seen all the evidence in this case and properly considered. During their closing arguments, the parties may mention points of law or refer to these instructions that the court has given. However, the law you must follow in reaching your verdict is the law that the court has given to you in these final instructions. If there's any difference between what the parties say about the law, what the court has said in these final instructions, you must follow the court's instructions. That concludes the majority of the jury instructions. It is 5 minutes after 12. Is lunch here yet? 15.
That told me.
Hopefully we're here right at noon, so it's back there for you, I think, at some point, relatively soon.
It's here, just set it up right now.
Okay, so what we're gonna do is, since lunch is here, typically takes less time to get through lunch. It is 5 minutes after 12, to bring you back at 1:15, where you will do the closing arguments, final small jury instruction, and sentence blue. Remember, you cannot talk about this until you're back to the jury room to deliberate after the vote and the final instructions have to be. That may step to the jury room. All right, please, so, parties have any matters to bring up before we break one?
No, Judge.
Let's not ready to close?
Yes, sir.
All right, court, this trial will be recessed to 1:15.
Anything left on the document?
Yes.
Let's go over it.